Will the House please come back to order? In accordance with the provisions of Uniform Rule 51, I turn the gavel over to the President of the Senate, the Honorable Gary Stevens.
Thank you, Madam Speaker. Will the joint session of the Alaska State Legislature please come to order? Madam Majority Leader.
Mr. President, I move and ask unanimous consent that the roll call of the Senate be waived and all members shown as present.
Without objection, so ordered. Mr. Majority Leader Sadler.
Mr. President, I move and ask unanimous consent that the roll call of the House be waived and all members be shown as present.
Without objection, so ordered. Would Senator Keel and Representative Carpenter please escort the Chief Justice of the Alaska Supreme Court to this joint session?
Ladies and gentlemen, the Chief Justice of the great state of Alaska, the Honorable Peter Maassen.
Thank you, and good morning. President Stevens, Speaker Tilton, other senators, representatives, and honored guests, thank you for the invitation to speak with you today on behalf of the Alaska court system. The state of the judiciary is, in a word, good. You may want me to leave it there, but I do intend to get further into the details later on. Unless you shout me down, you could do that as well. Like some of my predecessors, I began preparing for today by looking back at what earlier Chief Justices had to say on this occasion. The first address that comes up in the historical record is the one in 1972 by Chief Justice George Boney. You may recall that Chief Justice Winfrey referred to that in his remarks a year or two ago. What prompted Chief Justice Boney's address was a concurrent resolution of the Alaska Legislature, signed in 1971 by Jay Hammond as President of the Senate and Gene Guess as Speaker of the House. The legislature said, and I quote, "Although the judicial branch of government is an equal branch of our government, along with the executive and legislative branches, many legislators, as well as many members of the public, feel that a communication gap exists concerning the operation of the judiciary." The resolution cited the recommendation of Chief Justice Warren Burger of the U.S. Supreme Court that state governments help bridge this gap by having annual State of the Judiciary addresses just like they did at the federal level. And the resolution concluded by saying that the Alaska Legislature would welcome the opportunity to be addressed by a member of the judicial branch in order to get, and again I quote, "an in-depth view of the successes, problems, and goals of the judiciary." I want to thank you for continuing that 52-year tradition of welcome from your branch to ours. And I hope that what I have to say today will give you a good sense of what our successes, problems, and goals have been for the past year, as you have requested. But before I go any further, I want to introduce my colleagues who are here today. Sue Carney has her home in Fairbanks. She was appointed to the Supreme Court in 2016 after a career with the Public Defender Agency and the Office of Public Advocacy. She chairs a number of committees and serves as a mentor in the very important Color of Justice program that helps encourage Alaskan kids to take part in justice-related activities and maybe embark on justice-related careers. It was my pleasure very recently to give her the 35-year pin recognizing her years of service to the citizens of this state. Justice Carney. My colleague Dario Borgeson has been on the court since 2020, coming to us from a leadership position in the Department of Law. Among his many other responsibilities, he is co-chair of our Access to Justice Committee. He lives in Anchorage, and he's the justice most likely to be weathered in on a moose hunt. Justice Borgeson. Also from Anchorage is Justice Jennifer Henderson, who was appointed in 2021. She is the other co-chair of the Access to Justice Committee, and she chairs several other committees and working groups, including one that's focused on our criminal case backlog, and more on that later. She is one of 2 justices who have served as a trial judge, having been both a Superior Court and a District Court judge. And I can't tell you how valuable it is to have that perspective on our court, since it is literally our job to tell trial judges what they did wrong. Justice Henderson. The latest addition to our court, also a former trial judge, is Jude Pate, who was appointed last year. He lived in Sitka for over 30 years, where he served as counsel for the Sitka tribe, was in private practice, and was an assistant public defender before becoming a Superior Court judge. Now that he's on the Supreme Court, he has moved his chambers here in Juneau. And like my other colleagues, he is a workhorse when it comes to committee assignments, including leading our newer judge training. Justice Pate. A few other people in leadership positions in the court system that I'd like to introduce. Our administrative director is Stacy Mars. She has been with the court system for 20 years. First as director of our self-help and language access programs, and since 2019 as administrative director. She is a very proactive leader, and it's largely due to her energy and creativity that Alaska is a national model for innovations in access to justice. She is supported by a very capable staff in the administrative office and in all our locations statewide. Stacy. Next, I'll introduce a team that probably needs no introduction. It's familiar to most of you. And I'm introducing them as a team not because they're fungible, but because that's the way we view them. The question is always, what do Nancy and Doug think? Justices come and go, but Nancy Mead, our general counsel, and Doug Wolliver, our deputy administrative director, have been the face of the court system in Juneau during the legislative sessions for decades. We are so privileged to have them both come out of retirement to again help you understand our operations and our budgetary needs. Thank you, Nancy and Doug. I also want to recognize the executive director of the Alaska Judicial Council, Suzanne DiPietro, who has headed the council since 2014. Like Stacy Mars, Suzanne is nationally recognized in the field of court administration. She has written widely on legal topics. She's a font of information on Alaska's courts and legal history, and she has helped court systems in developing countries as far afield as Albania and Mongolia. She is a great administrator with a very capable staff. Thank you, Suzanne. And finally, I am honored to have in the chambers today my wife, Kay Gowans, who has her own admirable professional biography, but I'm not going to go into that. Kay is one of those many spouses who said, sure, I'll go up to Alaska for a year or two. I'm sure neither of us anticipated when we first met in college in Michigan that 50 years later, you would catch my eye again across this august chamber. So, Kay Gowans. Before identifying some of the court system's successes and challenges, I want to spend a few minutes setting the scene. We currently operate out of 38 locations across the state. It should be 40, but as you probably know, the building that housed our court facilities in Skagway burned down last February, and the space we were leasing in Hooper Bay became uninhabitable, and we haven't been able to find substitute space in either of those locations yet. But we hope to do so, because we recognize how important it is for Alaska's citizens to feel connected to their justice system. We want to be in those communities. Statewide, we have 64 judicial positions, in trial court positions, that is. Those are both Superior Court and District Court, with 4 vacancies that the Alaska Judicial Council is currently in the process of filling. The nominations have gone to the governor. We have 30 magistrate judges. These are judicial officers of more limited authority who are appointed by the presiding judge in each district. Some of them serve communities that wouldn't otherwise have a court presence, like Hoona and Seward and Aniak. Then there are the appellate courts, 4 judges on the Court of Appeals that does only criminal cases, and the 5 of us on the Supreme Court. And in addition, we have over 750 other employees in clerical and support positions. These include customer service clerks and in-court clerks, judicial assistants, people who work on financial matters and HR and IT and security, all of the people who are essential to a large organization like ours. When I introduced the justices and the other members of the court leadership, I hope you understood that we are just stand-ins for the hundreds of people across the state who work just as conscientiously to make a court system that is accessible and respectful and fair. We consistently take up less than 2% of the state's operating budget. Most of this is for personnel costs. But despite our low profile in terms of the state budget, the courts are a significant presence in the lives of Alaskans. During FY23, nearly 92,000 cases were filed in the state courts, in the trial courts. And nearly 18,000 people appeared for jury duty, both grand jury and trial jury. So you can see that thousands of your constituents are involved in the judicial system, not just as employees, but also as litigants, as witnesses, as victims of crime, as jurors, and maybe just as people who need to get a name change or manage an adoption. I'll give you a few more reference points regarding our caseload. About 30% of it is made up of civil cases, and a big part of this is family law, divorce, child custody, child support, dividing up marital property. Then there are disputes about debts, housing, and small claims. There are probate matters like appointing guardians for people who need them and dealing with the estates of people who have died. There are property disputes, which might be quiet title or easements or zoning matters, trespass cases. There are tort and contract cases, and there are proceedings to determine whether somebody should be committed for mental health treatment. There are also, a big part of our caseload, child in need of aid cases, where the Office of Children's Services has determined that a child is being neglected or abused, and the state needs to step in and either rehabilitate the family relationship or seek to terminate the parents' rights. Another 26% of this caseload is criminal, and of that, about 85% of the cases are misdemeanors, that is, where the maximum penalty is a year in prison. The rest are felonies, of course. And another 40% of the overall caseload is minor offenses, meaning mostly violations of fish and game regulations and maybe traffic violations. There's a small percentage that are juvenile delinquency matters and a few other things. But the cases that get the media attention, the ones that raise constitutional questions about voter initiatives and ballot access and subsistence rights and privacy rights, the occasional collisions between your branch and the executive branch, those are a very, very small part of what we see in the trial courts and on appeal. With this backdrop, I want to talk about some of our successes over the past year. And I'm defining success as an improvement in efficiency, in accessibility, and in Alaskans' perception that whatever the result of a particular case, the court system handled it respectfully and fairly. I sincerely hope that this is the last State of the Judiciary Address where a Chief Justice utters the word pandemic. But the pandemic did result in some changes in our procedures that were positive enough that we have formalized them over the past year through a series of Supreme Court orders. The first category is remote proceedings. You are all well aware of the challenges of court proceedings in Alaska because of the distances involved, the isolation of some of our communities, and the shortage of critical personnel in some positions. Looking especially at the agencies we see most often, the Department of Law, the Public Defender Agency, and the Office of Public Advocacy, they have struggled to keep lawyers in some court locations where their participation is really essential to the types of cases that are heard. Their lawyers often have caseloads that touch many different communities separated by hundreds of miles, and of course they can't be in 2 courtrooms at once, let alone 2 cities at once. Our courts have for a long time accommodated long-distance, telephonic, and other types of long-distance participation. And during the pandemic, most of our judges and in-court clerks became very adept at Zoom. In November, we, at the Supreme Court, implemented an order that attempts to both encourage more regular use of remote proceedings and to identify which types of court proceedings should be presumptively remote as opposed to presumptively in person. with the judges retaining the discretion to vary from the formula if the circumstances require it. For example, most evidentiary proceedings in criminal cases and other types of cases that involve trial or evidentiary hearings are presumptively in person, whereas a lot of hearings involving things like the status of discovery, scheduling, and settlement are presumptively remote. And the presiding judges in each of our 4 judicial districts are issuing orders specific to their own district's practices, whether that's Kotzebue or Fairbanks or Juneau, so we can make sure that this presumptive format works from one end of Alaska to the other. We have also worked with the Department of Corrections, and will continue to do so, to ensure that all jail facilities have working video equipment to make it as easy as possible for criminal defendants to attend their more routine pretrial hearings by video. This is a benefit to both the Department of Corrections and the Department of Public Safety by cutting down the number of times prisoners need to be transported back and forth with the attendant costs and inefficiencies and risk to public safety. Another category of improvement I want to highlight involves juries. During the pandemic, we developed some more efficient ways to use jurors. Because of the health risks of bringing a lot of people together in a jury assembly room, our trial courts called fewer jurors at a time and ended up using them more efficiently. This meant that Alaskans spent less time waiting for something to happen, and fewer prospective jurors were sent home unused, both of which can be very frustrating experiences. We formalized these jury practices for the long term in an order that we issued in August. The order requires that pretrial motions be resolved well ahead of trial, so fewer trials fold at the last minute after jurors are assembled and ready to go. It requires that jurors be called in smaller groups so that they spend less time waiting to be brought into the courtroom for the actual jury selection process. And we're trying to ensure that a lot of the other preliminaries, like excusals for cause and or challenges for cause and excusals for hardship, can be decided based on questionnaires that are sent to the jurors by email beforehand. Not that many cases go to trial in front of a jury, and you've heard these numbers before and are probably well familiar with them. It is consistently less than 2% of all criminal cases that are decided by a jury, the rest being either dismissed by the prosecution or settled, resolved by agreement between the prosecution and the defense. But either of these resolutions usually comes about because of the imminence of a scheduled jury trial. When cases do go to trial, the jury is a big ticket item. Jury expenses, including juror pay and travel, lodging, and meals, totaled a little under $2 million in FY23. Jury trials in Bethel and Dillingham, where many potential jurors have to travel to the court site by air, accounted for nearly $375,000 of this total. To help address this issue, in November we authorized a pilot project in Bethel, allowing jury selection by video conference in civil cases and criminal and misdemeanor cases, meaning that the jury is actually selected without the expense and inconvenience of bringing a pool of potential jurors into the court site just to see whether they will actually be among the chosen few who will serve. The jury is selected and then flown to Bethel for the trial. This should result not only in cost savings, which should be substantial, but also in a better juror experience. Before I leave the subject of pandemic-related changes, I have to highlight one of our most daunting challenges, also related to the pandemic, and that is our backlog of criminal cases. There were many months during the pandemic when jury trials were not happening, first because of the logistical challenges of getting a lot of people into a confined space, and secondly, because of agency attorney shortages that meant that there just weren't enough experienced lawyers to go around. Of course, as I just noted, jury trials aren't how most criminal cases are resolved. It's the threat of a jury trial that pushes the people to talk to each other and decide which cases should be dismissed and which should be settled. When the prosecutors and defense attorneys lacked this incentive, the process really slowed down. We recognize the impact that this has, not just on the criminal defendants, but also on family members and victims, witnesses, and the public at large. And we want to make sure that the court system is never the cause of this kind of delay. We're trying to address the backlog in a variety of ways. One way is to make better use of trailing calendars, as they've done in the 4th Judicial District. This means that if one case set for trial folds at the last minute, there's another one in the queue ready to go. Other approaches include limiting the number of allowable continuances and ensuring that every pretrial hearing is actually meaningful and not just an occasion to kick the can down the road. These approaches are part of orders issued just last week, or in the last week or two, by the presiding judge in the 3rd Judicial District. The working group that I mentioned earlier, which is chaired by Justice Henderson, is energized to tackle this problem aggressively and with creative new ways. The courts always stand ready to hold jury trials. We will find courtrooms. If necessary, we will bring retired judges out of retirement to preside over trials whenever the other institutional players are ready to go. And I am happy to say that the heads of the executive agencies, the ones involved in the justice system, the Department of Law, the Public Defender Agency, and OPA, are eager to do their part. We are going to work through this so that next year we can present it to you again as one of our successes. Now I want to highlight some positive changes that aren't necessarily related to the pandemic. First, a few things having to do with our relations with tribal governments and tribal members. In June, we issued an order creating a new rule for child in need of aid cases. This rule creates a uniform process for tribes' intervention in cases involving children who are subject to the Indian Child Welfare Act. As you probably know, federal law gives a child's tribe the right to participate in these proceedings, but we haven't had a uniform way for our trial courts to recognize that right. This new rule, China Rule 26, makes clear that all the tribe needs to do is inform the court of its intent to participate. There's no motion required, no other formality. We're also urging courts to make better use of Criminal Rule 11I. This is a rule that allows the judge in a criminal case to refer the matter to a restorative justice program in a criminal case, as long as the victim, the defendant, and the prosecutor agree. Restorative justice may include circle sentencing or another culturally based practice that incorporates input not just from the victim, but from the community at large. And it may result in a recommendation to the judge as to what the sentence should be. It's another way to help Alaskans see the court system as a part of the community, reflecting its values and not apart from it. There are another half dozen court system projects I want to touch on just briefly. The first is the Early Resolution Program. Our court has long been a national leader in access to justice projects, as I noted before, in part because making the justice system accessible across Alaska has required a lot of creative thinking. We've had a successful early resolution program for domestic relations cases since 2009. 80% of the cases that go into this program are resolved early in the process using mediators and volunteer lawyers and settlement judges. They're resolved often in just one hearing. This has been going on in Anchorage, Juneau, Palmer, and Kenai, drawing in cases from other regions. And in January, it started up in Fairbanks as well, covering even more territory of the state. The program has allowed thousands of Alaskans with issues related to divorce, child custody, and marital property to avoid most of the expenses and stresses of the adversarial system. Second, in FY23, we received a grant to create a statewide eviction diversion pilot program. And this includes an option to resolve housing disputes without any sort of court filing, just a negotiation with a neutral mediator. And this has also seen a lot of success. Third, we've been working with a vendor to develop a more general online dispute resolution platform by which parties will be able to negotiate, mediate, or in some types of cases even have a whole trial online, again, without the need to file a complaint or physically appear in court. And this can even happen after court hours when some people have difficulty getting away from the job. The platform can be accessed, well, it's now limited to debt-related cases, but we believe it can be useful for some housing issues, post-judgment parenting plans, and maybe traffic cases, again, with the goal of helping people resolve their legal issues without all of the logistical challenges that sometimes face them when they want to come to court. Fourth, we have an ongoing guardianship improvement project that makes use of federal grant money to improve our handling of guardianship cases. These are one of the fastest categories of cases in our system. We've hired special monitors to help family guardians with the regular reporting that's required by statute. Supporting family guardians in this way makes it less likely that the public guardian will be called upon to step in. Our budget request includes funding to continue and expand this work to support private guardians. Fifth, with the addition of Anchorage and Palmer in just the past month, all of Alaska's courts now have electronic filing in criminal cases and minor offense cases. We hope that e-filing will encompass all case types in courts by the end of 2026. And sixth, we are piloting a digital evidence management platform. Very often these days, parties show up in court with their evidence on flash drives or their laptops or their iPhones, and the judge has to be able to see this evidence and show it to the other parties and incorporate it into the record, and all of this without putting our own court computer system at risk of viruses and malware. It can be a particular challenge when it's a hybrid hearing. Some parties are remote and some are actually in the courtroom. But this platform allows anyone with a screen to have the same view of the evidence at the same time. It's cloud-based, so it doesn't touch the court system's computer system. And it has neat features for marking and editing documents, things like that. It will be rolled out for the first time in a hearing later this month in Bethel. And again, our plan is to extend this program statewide. There is one other project I want to mention that affects the public face of our court system, and that is an important updating of the Alaska Code of Judicial Ethics. It's being done by a committee led by retired Justice Winfrey and also retired Court of Appeals Judge David Mannheimer. Judicial ethics have been in the national news this past year. There is a public perception, rightly or wrongly, that some courts and some judicial officers aren't subject to ethical rules regarding conflicts of interest and financial disclosures. That perception could color the way that citizens view all judges and all courts. In Alaska, the Code of Judicial Conduct does bind every judicial officer, top to bottom, and we take it very seriously, as does the Judicial Conduct Commission, which polices the enforcement of, has the task of enforcing the code. And we judges also report our finances to the Alaska Public Offices Commission, just like you do. All of Alaska's judges receive a weekly report from the National Center for Judicial Ethics, which is a clearinghouse for this type of information. In fact, I just got another email from them this morning. The report describes the ethics complaints that have been brought against judges across the nation, both federal and state. Every week there's another dozen or more, and some of them, describing the sorts of trouble judges can get into, are really pretty appalling. But one thing you almost never see on that list of cases is the word Alaska. This is a credit to our judicial selection process, to our judicial education, and ultimately to the quality of people who serve as judges in our state. I want to turn now to our budget request and highlight just a few aspects of it. First, you can see by all the projects that I've mentioned that Alaska's courts are very dependent on technology to serve our state's very diverse legal needs. We're requesting money this year for an emergency technology fund that would roll over from one year to the next if not used. The money would be available to address situations like a cyber attack when, as we know from very recent experience, we would need to act on short notice to hire forensic consultants, deploy expensive software to identify the extent of the intrusion, and probably revamp our entire security system. Another state's court system had a major attack last year and was offline for several months. A county government in Georgia, including its court system, was attacked just last week, and Pennsylvania's courts were hit just the day before yesterday. So this is a real problem. Federal experts warn us that courts are a particularly popular target for this sort of attack and need to be especially vigilant. Many state courts have created this sort of emergency technology fund, and we hope that you will consider it seriously. Despite all of this technology, we still need actual brick and mortar courthouses, buildings that are both functional and secure. Alaska's courthouses run the gamut. Some are owned by the court system, some by other executive agencies, and some we lease from tribes or cities or private landlords. Many of our buildings weren't built as courthouses and required a lot of renovation before they were usable. And then, of course, there's the weather, and this causes roof leaks and frozen pipes and shifting floors and decaying asphalt in the parking lots. We have a lot of deferred maintenance issues that we do our best to keep up with. We took the step in 2022 and 2023 of having a conditions assessment done on all the buildings that we own. This resulted in a timeline for replacing necessary systems like boilers and air exchanges, elevators, and roofs. We are very grateful for the support we've received from you on these projects in the past, and for us to keep the doors open. I hope you realize that we need your continuing support. You are all familiar with the population trends in Alaska, including the outmigration, which should mean a decreasing caseload for the courts. But there is one place in the state where there is a growing population and a corresponding increase in the caseload, and that's the Mat-Su Valley. The Palmer judges already have the highest per judge caseload in the state. Last year, you gave us the funding for an additional magistrate judge position, which we filled, and that helped a lot, particularly with probate cases. But space is still an issue, and demographic trends being what they are, the Palmer Courthouse simply isn't big enough to keep up. This past year, we worked with the designers on a plan to add 3 courthouses and some flexible space to accommodate hearings and office space, with the option to build upwards eventually in the future if it becomes necessary. Our capital budget request this year includes funding for this Palmer addition. Again, it's badly needed, and I hope you see its value. And just a word finally about Bethel. We're grateful for last year's funding for the design of a new and badly needed Bethel Justice Center, which we expect will involve other justice agency partners in the executive branch and tribal organizations. We haven't included any additional requests related to this project in this year's budget because we're still in the design phase, but you will be hearing more about it in the future. We have high hopes for a new building that will be functional and welcoming for people from throughout the region. And speaking of Bethel, I want to close with a few words about a trip I took just 2 weeks ago with the other members of the Alaska Judicial Council. As you know, the Council has the constitutional duty to assess the candidates for judicial positions across the state and send their nominations to the governor. There are 6 people on the Council besides myself, citizens from Juneau, Kenai, Anchorage, Wasilla, and Fairbanks, all of whom take their work very seriously. We spent a week in January talking to candidates for Superior Court positions in Bethel and Sitka and then here in Juneau. You can't go through that process without realizing several important things about our state. The first is that people really love where they live, wherever that might be. You'll get the same message in Bethel that you get in Sitka and Juneau. This is the best community there is. And the reason maybe has something to do with the natural beauty or the opportunities for employment or recreation or hunting and fishing, but most likely it's because the people are the best. They're friendly, they're involved in their community, and they watch out for each other. The other thing you notice on these trips is that there is a wealth of talented and accomplished people throughout Alaska who could be doing almost anything with their professional lives but have decided to go into public service. This is true not just of the judicial candidates, but also of the other people who work in the courts and are the face of the Alaska court system in their communities. I have to take this opportunity to thank all of them for their good work. And on their behalf, I thank you again for the opportunity to talk to you about our successes, our problems, and our goals. And I wish you a great deal of patience and wisdom in the challenging weeks you have ahead. Thank you.
Madam Majority Leader Giesel.
Mr. President, I move that the joint session adjourn.
Without objection, the joint session is adjourned.
The House will stand at ease.